Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Juris, and it's an important book on arbitration. They are leaders in their own field concerning international arbitration, and this book is entitled Interim and Emergency Relief in International Arbitration. It's been edited by Diora, Ziyaeva. Now, I hope I've pronounced the name correctly. There are general editors to the publication as well. That's Laird, Borzu, Sabahi and Anne-Marie Whitesell. And it's been produced, as I say, by Juris from America. It's part of the International Law Institute publications, and it's the series on International Law, Arbitration and Practice, Volume 1. Now, we think this is an illuminating read, this book. What we've given it as a title, Elizabeth and I talked about the book, and we gave the title of our review this: For International Lawyers and Arbitrators, an exploration of interim measures in resolving cross-border and international disputes. Let me show you the book first of all. It's a hardback, blue cover. There we go. Front, spine, and then you've got the back there. You've got the logo at the top there. And you've got quite a large number of contributors all mentioned at the back there. I can't go through all of them by name, unfortunately. There is a useful index, which you can see at the back. I wouldn't say it's particularly detailed, the index, but it is useful. You can find things pretty quickly. You've then got the body copy of the book itself running all the way through. You do have some footnotes, which you can see mentioned there. That's in the middle of the book. That's dealing with provisional measures. You've then got, for instance, in part 3, keynote speeches there which are given. Now, what we'll do is we'll go to the front first of all, and you get some idea of how the book is structured. It starts off with the front page here, which you can see. Then you go from that into the dedication, which is nice, to William Mays. Then you've got after that the table of contents which are listed there. Part 1 starts off with the power of arbitral tribunals to offer interim relief. Then it has a number of chapters. Then part 2, you then have part 2 on national court powers. Part 3, the keynote speech, which I mentioned, of Mr. Yu Jianglong, who's Secretary General of CIATAC. And then you've got part 4, interim relief in investment treaty arbitration there. Then part 5, emergency relief in international arbitration generally, which is covered there. There's a foreword by Charles Owen Verrill Jr., which is always worth a quick read. Then acknowledgements, because this book has been very well sourced. Then there's a detail about the editors, the main editors, general editors, and the people who contributed here. A lot of people have been involved. So it says difficult for me to mention all their names, but you see that there are a lot of people who are covered here. Then there's an introduction to the series by Laird, which is given there, as to what they're really trying to sort out. Then a main introduction to interim, preliminary, provisional or conservatory measures or relief. Obviously some of the words that we are using here do tend to be slightly different from, say, some of the words you might be familiar with in the English jurisdiction. But there again you can see powers of arbitral tribunals to offer interim relief is covered there. And then it goes through from that. The book runs to 350 pages in total. It's an interesting book, and certainly because of the position the common law jurisdiction is in England and Wales, the whole concept of arbitration is an important area for us, both nationally and internationally, which is one of the reasons why I, as a practitioner at the English bar for England and Wales, see this book as very helpful in terms of a much wider field of activity, and therefore will be relevant to a lot more people than just people directly involved in matters which I have, say, at the English bar. Now, we have said the following about this book. We say it's an illuminating read, which is what I talked about earlier, for international arbitrators and lawyers, and it highlights the various and pertinent aspects of interim measures as collectively a vital component in the processes of international arbitration, bearing in mind that, in the words of the editor, international arbitration continues to become the preferred method of resolving cross-border disputes. Excuse me. The editors expressed the view that interim measures have been widely recognised as an important aspect of all arbitral rules, and certainly an effective mechanism for enhancing and maintaining confidence in the international arbitration system, whilst of course ensuring its effectiveness in future years. And reflecting the recent surge of interest in this topic, particularly in 2014, an important conference was organised by the International Law Institute, the ILI, and its sponsors let it take place in the April of 2014, which elicited the views of a team of international experts in this field from a variety of academic backgrounds and cultures. The resulting papers comprise this book, which explores the latest developments in both international commercial and investment arbitration, with the focus on what are variously known as interim, preliminary, provisional or conservatory measures, and that's how the book actually starts off. So that should give you some idea, depending on what your problem is, of what you would be actually looking for in the book. Whatever the preferred term for these mechanisms then, they have obviously developed over time as a means of minimising the risk of prolonging disputes, including the kind which may well threaten human life or welfare or assets, hence the concept, of course, of emergency. The objective here is to protect the general integrity of the arbitration proceedings and the ultimate respect in which they are held. And the ILI, by the way, is an international organisation founded at Georgetown University in Washington, D.C. in 1955, and it's to assist in the rebuilding of institutions in post-war Europe. Another legacy which we are, of course, on this side of the Atlantic, extremely grateful to the Americans for. It now provides training and technical assistance pertaining to economic and legal developments, mainly in developing countries. And again, this gives you a flavour of the common law influence across the planet, and the fact that we owe a lot of debts to our colleagues in the United States, and obviously this is something which covers a much wider rather than a much narrower set of jurisdictions. Early on, for example, it held, this is the organisation, held various conferences in connection with the administration of trade remedy laws across a range of economic models. That's pursuant to GATT, that's the General Treaty on Tariffs and Trade. So you can see from that the international flavour throughout. The book's been published by Juris, and it's the first book in a planned series of regular conferences and related books to be published by the ILI together with Juris, which is part of the International Law Institute series on international law, arbitration and practice. So it will form a much larger library of books in the end. And the series as a whole will focus on the key issues of theory and practice in international law and arbitration, particularly in international commercial and investment matters. And the book covers a range of arbitral situations over a wide cross-section of countries, from Asia to the Middle East and to North America. The global perspective it offers, we think, based on an impressive body of research, will be of immense value to those who work professionally in this field, and I think it's a great contribution to this particular area of professional activity. And the publication date is cited as at 2015. Let's just have a quick look at the book again. It's a paperback, as I say. Here we go, spine and then the back. Some nice points about the various people involved in the publication. Just opening it in the middle. You see some of them have got quite a lot of footnotes, some of the chapters. And there's a lot of detail that's gone into this. So you can see, for instance, just going a little bit more into the book itself there. That's interim relief itself. The forms of emergency decisions that are made, because sometimes you are looking at making decisions very quickly, and one of the problems in this area, like in many areas of law, is the amount of time it takes to get decisions. There's the index again at the back. It's a little disappointing in some ways, not quite as big as I'd have thought, but you should be able to find most of what you're looking for in the front section as well, the content section, and the contributors are named in each of the chapters, which is helpful, so you know who's actually written which a particular chapter. As I say, the foreword is well worth reading. I'd like to thank Juris very much indeed, and all the people involved, a large number of people involved in this publication, and we welcome it very much, and of course the sister publications which are to follow. So thank you, Juris, and thank you to all concerned very much, and we will look forward to some of your further deliberations in the course of time. Bye bye for now.